My name is Nicole Hemrick, and I am the managing attorney at Hemrick O'Malley, PLLC in New York City. Today, I'd like to discuss an important question that Frederick from the Bronx sent us. He asks, I am married to a U.S. citizen, but I have a deportation order from 10 years ago. Can I get a green card through my wife? The answer is maybe. If you have an old deportation order, but you have an approved petition, whether that's an employment-based petition or a family-based petition, you may be able to still adjust your status. And how this is done, there are certain complexities given the type of case you have. This certainly requires discussing this with a licensed attorney, but we will just go through some basics here. If you entered as an arriving alien, you may not actually need to reopen your case. You might be able to go straight to USCIS to get your case adjudicated. If you were admitted and inspected into the U.S., then you will likely have to get an approved petition first, meaning an approved I-130 or I-140, and then present that approved petition with a proposed adjustment of status application and your written legal reasons as to why you are eligible to adjust your status and what your case history was before. You would present this in a proposed joint motion to the attorney's office for the Department of Homeland Security. They would review this submission and then send you a response saying, yes, we are joining in this, or we decline to join. If they accept to join, fantastic. You submit the motion to the court, and the court should reopen the case at that point. If they decline, there is nothing preventing you from submitting it to the court. The court might choose to reopen it sua sponte, which means on their own accord, but it makes it a little less likely that the case would be reopened. Once your case is back in court, then you have two choices. Either you might adjust your case before the court, meaning that the judge would take testimony regarding your eligibility for your green card, or you might request a dismissal or termination so that USCIS can decide on your green card. Please be aware there are certainly complexities here. First of all, if this is not an immediate relative petition, meaning it's not an I-130 filed for you from a U.S. citizen spouse or a U.S. citizen son or daughter, meaning the person is over 21, you will in most cases have to demonstrate that you are eligible for adjustment of status under 245I, also known as the Life Act. Also, if there are any issues in your past, such as a fraud or misrepresentation, or if you have a criminal history, you may require a waiver. And in that case, you might have to submit a proposed waiver application along with your submission. So this is certainly not a simple or cut and dried process, but it is a process that we have helped many individuals through successfully over the years. And we'd be happy to discuss your particular case with you and how we can move forward in getting your green card, even despite a prior removal or deportation order. If you would like to discuss this sort of issue or any other immigration issue, feel free to call us at 833-848-7838. Thank you very much.